It's a pleasure this morning to be part of this great initiative. And I want to especially thank Jody Michon and Dorothy Colby for arranging this. Both Jody and Dorothy, of course, are leaders in this field of addressing dementia, assisting families, making life just a little better for everybody. And and I want to thank you for that. And Diane Terada, thank you very much for the support that we have seen over the years. And the sponsors, the Administration for Community Living, the federal sponsors, Catholic Charities of Hawaii, the Circle of Care for Dementia, Hale Kuiki, of course, and that's Dorothy's platform we're using today. And on behalf of the University of Hawaii Elder Law Program, I want to express my support for these initiatives and also my thanks for being included because very often legal issues are not addressed as early as they should be. And hopefully in today's presentation, you'll see why it's important to look at some of the legal issues because every state has different laws and some laws in Hawaii are quite peculiar. And with that in mind, I hope that will keep you all interested to figure out the peculiarities. I've already looked at the early results of your polling and we have some work to do today. So this is great. I'd also like to announce the University of Hawaii Elder Law Program's 30th anniversary this year. It's hard to believe that we have been at the university for 30 years. And in celebration of this anniversary, we had this very beautiful Deciding What Matters and What to Do handbook that's available online. So we have a very simple website to access this book. It's available at hawaii.edu/UHELP. And of course, that stands for the University of Hawaii Elder Law Program. So you'll see a picture of the book on the front page of this website. You can just click on the book, and then we have all sorts of other resources up there. And we hope that you follow through with this session and look at this legal handbook because all of the subjects that I'm going to be talking about today are covered in this handbook. And I might add that thank you very much for for what you're going to be sitting through. Law students and nursing students and School of Medicine students sometimes take an entire semester to go through all of these issues. So this will be quite a feat to get through all these topics today, but we'll try to make it as enjoyable as possible. So here are the topics: decision-making capacity standards under Hawaii law. We'll look at a couple examples of how Hawaii law has defined certain issues regarding capacity, because when we're talking about dementia, it's not like turning on and off a light bulb. There may be stages, and there still may be some decision-making capacity left in individuals who have been diagnosed with dementia. Dementia itself as a term is somewhat controversial, and there's a trend towards moving away from that term, but it's the term that people understand. When you hear, you understand that it's something to do with the mind. We're going to be talking about just a little bit about guardianship and conservatorship. We're going to specialize more in the alternatives to court intervention. I changed this lecture slightly for the law students because today we're going to say, oh, you want to try to avoid those guardianship and conservatorship because it's very expensive and can be very expensive and can be quite time consuming. For the lawyers, well, that's not so bad, is it? Because guess who's going to be getting the money is this future lawyers and current lawyers. That just a little bit of humor, but you may think it's true that yeah, we but we do preach alternatives to court intervention in our classes, because one should have a plan, and it should not necessarily involve having to go to court to get things resolved, although the courts are there in case something goes wrong. A little bit about supported decision making in Hawaii. David from the American Bar Association talked about the trend across the nation with respect to supported decision making in Hawaii. Several states have laws, but Hawaii lags behind in this area, as well as in some other areas with respect to looking at issues regarding dementia. But there is no Hawaii state law in it, but we'll fit that in a bit too. Powers of attorney under the 2014 Hawaii Uniform Power of Attorney Act. Now, I saw the polling on that, and yeah, we need to discuss what the new law says about the powers that are granted. And some of you may be quite surprised. Some of you may have powers of attorney that are executed prior to 2014, so you should pay special attention. If your loved one with dementia has one that was executed prior to 2014, don't tear it up. It's perfect. It can be perfectly fine. But if you have a chance and you or your loved one is still mentally capacitated, you should consider making one under the 2014 law. So we'll talk about that. Advanced healthcare directives and other healthcare planning tools under Hawaii law. This is so important. I serve on the ethics committee of a large hospital here in Honolulu. This comes up every time we have a meeting. Who is making healthcare decisions for the incapacitated person? What decisions are made? Who is a legally authorized representative of the incapacitated person? What about conflicts between the surrogate decision maker, the agent or the guardian, and the patient preferences? We'll talk about that too. This area will also include provider orders for life-sustaining treatment, or POLS, which are very popular today, and they serve a very useful purpose. But you should know how easy it is for somebody else to change your order that you signed with your doctor or advanced practice registered nurse. And then we're going to engage in the area of Hawaii laws protecting persons from abuse, neglect, and exploitation, and especially our Adult Protective Services statute. It's very important that we know that COVID-19 has had a huge impact on older persons. And so here are a couple of quotes with respect to COVID-19 and the impact which it has had, including reports of elder abuse on the population directed against older individuals. In today's newspaper, there was also an article just on the science that the individuals with dementia may be more susceptible to COVID-19. So this area of protecting and providing resources to individuals with dementia couldn't be much more important. And we're all hoping, of course, that our government officials see it the same way and dedicate sufficient resources to addressing dementia. The theme I'm going to be looking at is the balancing autonomy and self-determination with best interest and protection. Just because a person has dementia doesn't mean that they lose their rights to as much autonomy and self-determination as possible. And if they have expressed what they want in advance, those desires normally speaking, should be followed. So we're talking about empowering people with diminished capacity to fully participate in life and to direct future decisions. This is what we talk about in healthcare decision making. That's why these some of the documents are called advanced healthcare directives, because it's in advance are um, that we are making these documents to tell people what we want and who we want to have carry out these important duties. We'll see that similarly with other alternatives to guardianship and conservatorship. We're also talking about avoiding overly restrictive interventions often used to assure protection. Um, yes, protection is important, but sometimes severe or restrictive interventions um, can really impinge upon a person's own desires with respect to how they want to live. Using mediators and other facilitators to help address the areas of potential disagreement and conflict among family members and caregivers with respect to care and support a person with dementia. I'm happy to hear that the next session is going to address this very topic. So I encourage you to enroll in the next webinar. And of course, when we're balancing autonomy and self-determination with best interest and protection, we have to address protecting persons from abuse, neglect, and exploitation. And once again, persons with dementia may be more susceptible to abuse, neglect, and including self-neglect and caregiver neglect and financial exploitation, as is the general older population. We continue to have what may be called a hidden epidemic of abuse because much of the abuse is hidden. For lawyers watching in, you should note Rule 1.14, the Hawaii Rules of Professional Conduct, where we have issues relating to clients under disability. And then we also will have the requirements for healthcare professionals to report report cases of suspected abuse to adult protective services. Capacity for what? So we're always asked to talk about capacity. So I throw back the question, capacity for what? There are decisional capacity levels that are required, and they are varying levels for each specific decision that needs to be made. So, for example, starting at the lowest level of capacity within the legal spectrum is the will. It only requires a minimal capacity level to execute a will, but powers of attorney, healthcare decisions may require a higher level. But for wills, we have hundreds of years of standards with respect to how a person can be deemed to have sufficient capacity to tell the world, to tell the state who they want to give their worldly goods to upon their death. And it's such a natural thing to want to give your assets to your loved ones or other persons, or not so loved ones, perhaps even upon your death. So we'll see a little bit about that in a second when we talk about specific capacity issues under Hawaii law. Who is making this assessment? In our lawyers' offices, we see that attorneys, generally speaking, make their own assessments of capacity. We don't require a physician or a psychiatrist or psychologist. We don't require them to provide their assessment necessarily, unless we think we need some more help with respect to issues of potential limited capacity. And then we might want to bring in an expert, a physician, for example, a geriatrician. And you had already in this series, you've had a geriatrician talk with you. You've had a couple of geriatricians. And I know that was a very popular webinar. And since they're archived, if you didn't attend that session, I would suggest that you look at those sessions. Psychiatrists, of course, provide assessments of capacity. I should also note that psychologists are in this field, and they provide a slightly different perspective on testing for capacity. As a matter of fact, later on today, I have a psychologist coming to class, my advanced legal studies in healthcare, health law, to be talking about assessments, and including assessment of capacity to make wills, powers of attorney, healthcare decision making, and in future sessions about other areas of capacity which are slightly different, such as fitness to stand trial. Capacity and undue influence are different, but they're very often linked. Very often you'll see a person with diminished capacity be more subject to undue influence, although an individual with what we may think of as complete or just perfect capacity, if there is such a thing, can also be subject to undue influence. We've all seen people who take advantage of individuals, and that's one way of exerting undue influence. And we see example after example of individuals getting something from an individual, or having that individual do some course of action under that undue influence. And finally, this whole subject area, we have to think about decision making in the absence of capacity. When the individual, we all agree, completely lacks capacity. And a simple example is with a person in a persistent vegetative state or in a coma. They don't have capacity. So we'll look at some legal instruments, we'll look at advanced directives, and we'll talk about this term surrogates, because in English and across the country, surrogates means something, but under Hawaii law, it's a very particular definition that we have on surrogates under the Uniform Healthcare Decisions Act that I will show you a little later on. So here we have different capacities under the law, and each specific capacity, as I mentioned, may require a different level of capacity. So the provision of informed consent for medical treatment, the execution of a will, a trust, an advance directive, or power of attorney. So I'll give you a couple of examples of for specific capacities under the law. So under Hawaii's Uniform Healthcare Decisions Act, they define capacity. Capacity means the individual's ability to understand the significant benefits, risks, and alternatives to proposed healthcare, and to make and communicate a healthcare decision. So when a healthcare provider, such as a doctor or a nurse, is asking you questions and providing you information and engaging you in conversation, they're also trying to figure out if you understand what the significant benefits, what the risks may be, and if you understand the alternatives to proposed healthcare, and whether or not you're able to communicate a healthcare decision. This is why it's important when you're looking at decision making in an attorney's office or even in a doctor's office, is when a person, let's say with some stage of dementia, appears with a caregiver or a family member, we will ask that we talk to the client alone, so we can see if we think that the person has capacity and is not being given the answers, or sometimes, as you know, you'll have somebody coming in with the older person, and the question will be asked, and it'll be answered by the companion, not by the patient or the client. So doctors, lawyers, other professionals need to be assured that the individual has capacity, and also by you should know that this method also helps us to try to see if there may be some form of undue influence also. So we have a little discussion with the individual. Under the Adult Protective Services Act, we see that capacity is slightly different, but it has some similar bearing. It's the ability to understand and appreciate the nature and consequences of making decisions concerning one's person, or to communicate such decisions. The law points out that exploiting a vulnerable adult through undue influence may constitute abuse under the law, and the exploitation may involve coercion, manipulation, threats, intimidation, misrepresentation, or exertion of undue influence. So in several areas of the law, these two concepts of capacity and undue influence are addressed. So here we are for one of the lowest levels of capacity for a legal document, and this will be in making a will. And according to the statute, an individual 18 or more years of age who is of sound mind may make a will. Well, that sounds pretty simple. So we have interpretations by the court of what is capacity, and we have a sort of an older case on this, but in this case harkens back to many years of common law brought down through England, and through our U.S. Constitution and our state law. And in order to be considered a sound mind, the court indicated that a person must understand the nature of the act being performed. That means they understand that this is a will, must know the nature and extent of one's property, must be cognizant of the natural objects of one's bounty, and must be capable of forming an orderly scheme of distribution. So they know what they have, they know who's related to them. The natural object of one's bounty are the spouse, the children, grandchildren, maybe brothers and sisters. And they must be capable of forming an orderly scheme of distribution. Says, okay, I want all 4 kids to get everything equally. So that would be enough. These are just a couple of examples of capacity being addressed in the statute, and if necessary, to be interpreted by the courts. I told you that it's probably good to try to avoid guardianship and conservatorship because it takes such a long time. But also, there are a couple of practical reasons that you may wish to do this. Guardianship and conservatorship are the legal mechanisms by which the judgment of a more capable person is substituted for a judgment of an impaired person. And this is for decisions to manage the personal affairs, that would be for the guardianship, and property, which would be the conservatorship. Only a court can appoint a guardian for a ward. A ward would be under guardianship, or a conservatorship for a protected person. Protected person is a conservatorship, and medical testimony is usually required. So the court is going to rely on the expert testimony, generally of a doctor or another skilled person, such as a advanced practice registered nurse who is um, qualified in psychiatry or psychology or geriatrics. Um, but generally speaking, you see medical doctors and psychiatrists and psychologists writing to the court or testifying in court under rare circumstances. Guardianship should and conservatorship should only be considered when the person's incapable of communicating necessary decisions for his or her own safety or for the property interest. And I underline this, suitable or effective alternatives have not been set up or are not available. I mentioned a couple times already, it can also be expensive and take a long time. I underlined suitable or effective alternatives have not been set up. Yes, we're going to be talking about and encouraging setting up these alternatives, but they may not be available. We see it very often that as people get older and they lose their family and they're left alone, maybe the person that they have appointed is no longer alive, is no longer available, is no longer capacitated. So even though a person has set up suitable, effective alternatives, they may not be available. So there may be a number of circumstances under which all the plans you have made are no longer available or possible. Guardianship and conservatorship, the judge is supposed to balance the autonomy and self-determination against protection and best interest. And judges have the duty to see that the autonomy and self-determination is preserved to the greatest extent possible. Practically speaking, guardianship and conservatorship cases are very quick. You know from the newspapers and from other media that there are some famous cases that take weeks and weeks and weeks in court, but generally speaking, they're very perfunctory, and many times the subject of the guardianship or conservatorship is not even in court. Another thing that you should realize is that guardianship is different from involuntary civil commitment. People call us with respect to individuals who have mental disorders, and they are imminently dangerous to self or others. And this is not the area for a guardianship or conservatorship. They may need one, but for the immediate interventions, we're looking at involuntary civil commitment or involuntary treatment in the community. Again, I'm packing in quite a bit of information that would take a semester for future lawyers and future geriatricians and doctors of nurse practice. Under the Uniform Guardianship and Protective Proceedings Act, we also have terminology. And what is an incapacitated person? Well, here's their definition under the statute that the legislature gave it. This means an individual for reasons other than being a minor, because there's guardianship of minors, of course, but for an individual who is unable to receive and evaluate information or to make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, or self-care, even with appropriate and reasonably available technological assistance. So technology enters into this, but it's factored in when an individual may have the ability to function without the need of a guardian or a conservatorship with technological assistance. I might also add that this is an area where we pause and say that in several states and in other jurisdictions across the world, you'll see that there are other methods that are used to assist an individual, to provide an individual with a level of care and a level of support through which they may not need to have a full guardianship. But if you appoint an individual to provide protection and services to another, and they are and there are resources in the community provided by law, then it makes it a lot easier for the judge to say, well, we're not going to impose a complete guardianship. We may impose a limited guardianship or conservatorship for a specific person, but they may not need to have the um, full guardianship if there are resources in the community. Hawaii is lagging behind in this area. About a half a dozen states have these services available to individuals and make it part of the process where individuals who may have limited capacity, physical or mental, receive services under a court order or in lieu of having a guardianship or conservatorship. Now, just an interesting concept for individuals. Hawaii, of course, has some specific terminology that no other state has. And in Hawaii, there is a kokua kanawai, or helper in the law, and that's used instead of the term visitor or master in other states. And this individual is not an advocate for or against the rights of an individual, but is the role is in responding to the petition for protective proceeding. And the kokua kanawai, without prior court order, has no authority to initiate actions on behalf of the protected person. Rather, the court could appoint a guardian ad litem for the protected person. So we have various abilities within the court system to provide individuals to look into matters, to receive information, or to provide to initiate actions on behalf of the protected person. Once again, terminology: ward is to guardian, as protected person is to conservator. Under the old law, the terminology was guardian of the property, and some of you may have documents from loved ones through which a guardianship was accomplished. So you may see the terminology guardian of the property, but now it's changed now to conservator. And under the new law, what used to be guardian of the person is now simply guardian. So when you're looking through your loved one's documents and you see guardian of the property, that translates now to conservator, and guardian of the person is now simply guardian. When may a court appoint a limited or unlimited guardian for the respondent? It can only do so when it finds clear and convincing evidence that the respondent is an incapacitated person. And I mentioned the medical testimony that they generally receive. And the respondent's identified needs cannot be met by less restrictive means, including the use of appropriate and reasonably available technological assistance. So this is where the court has a hearing, and these are the this is the way, the only way that the court would grant a guardianship. For conservatorship, there are two basic areas. We'll see a similar area of, as with the guardian, Um, and it's by clear and convincing evidence the individual is unable to manage property and business affairs effectively because of an impairment in the ability to receive and evaluate information or to make or communicate decisions, even with the use of appropriate, reasonably available technological assistance, or because of some other physical, mental, or health impairment. Or interestingly, and we had a case many years ago, because the individual is missing, detained, or unable to return to the United States. So we had a case where an individual had been missing for numerous years, just disappeared. And so a conservator was appointed. Um, and then eventually the person was declared to be dead under a different statute. Uh, the second area is by preponderance of evidence, which is a lower level of evidence that the individual has property that will be wasted or dissipated unless management is provided or money is needed for the support, care, education, health, and welfare of the individual, or of individuals who are entitled to the individual's support, and that protection is necessary or desirable to obtain or provide money. So it could be the spouse or the children are relying on that individual, and the individual is wasting the property, such as spending the money, gambling, etc. When we talk about alternatives to guardianship, one of the alternatives that one could consider is a limited order. So you could consider a limited versus what is called a plenary order for guardianship. And the guardian is assigned only those duties and powers the incapacitated person is incapable of exercising. Now, this is what the court is required to consider. Many judges, it seems, are of the opinion that, well, we know it's just going to get worse, so let's go ahead and grant it so we don't have to come back and have another hearing. But more and more judges are limiting the powers when the incapacitated person demonstrates that they can still function in some areas. So there are protective orders that can be initiated by the judge. And there can also, under the conservative side, again, we see parallels, but you can have a conservatorship for a specific purpose. One example is the only thing grandma has is that bank account. Everything else is taken care of. So instead of going for a full conservatorship, there can be a petition just to have authority to get into that bank account, to use it, to close it, to whatever the judge approves. So those are some examples of limited guardianship and conservatorship for a specific purpose. What are these alternatives to guardianship and conservatorship? I mentioned that we have a limited guardianship and conservatorship. Also, the concept of providing extra help under a statute, which is that concept of supported decision making. We don't have a Hawaii statute as of now, but in some states they do. And in some countries, they appoint this an individual to provide services, to provide care, to help the person, to support them in their own decision making. In Hawaii, unfortunately, very often a guardianship or conservatorship will be initiated because there is no specific supported decision making statute. But this is something that the legislature, I'm sure, will be dealing with as they see other states go forward in this area. For selected traditional alternatives that are very common throughout the years. Um, we divided up into two areas: personal and financial and legal matters. So you can almost see somewhat of a split between guardianship and conservatorship for alternatives. But in some areas, there will be an intersection, and that especially will be with powers of attorney under the Uniform Power of Attorney Act. So for personal matters, that would be an alternative to guardianship. You would see powers of attorney under the Uniform Power of Attorney Act. I'll get into greater details, but we'll also see advanced directives, including healthcare power of attorney. I specifically mentioned the healthcare power of attorney on this slide because under the 2014 Uniform Power of Attorney Act, which is the regular Power of Attorney Act, that changed the law to say that you can't have healthcare decision-making powers in a power of attorney executed under the Uniform Power of Attorney Act. So I see almost a 50-50 split on that one. So be sure to know that in that power of attorney for the regular, probably a general power of attorney when you're planning for the future, I'll get into that terminology soon, but that doesn't include healthcare powers anymore. Some of you may have powers of attorney executed prior to 2014 that do include powers of attorney. Now, if it's for yourself, you may consider making a new power of attorney, a new advanced healthcare directive, including the power of attorney for healthcare. Once again, if it's for a loved one who has dementia and no longer has decisional capacity, don't do anything. Don't tear it up. Don't destroy it, because most of the time, the language in there will be sufficient to take care of both the healthcare and the other needs. But for current powers of attorney, the law says if you are giving healthcare powers of attorney, go to the Uniform Healthcare Decisions Act, where it says under their UHCDA, to put it in a durable power of attorney for healthcare. For personal, including healthcare matters, of course, we have the provider orders for life-sustaining treatment that I mentioned already. We'll see that has some issues with respect to people changing them and it can be for good reason. Of course, people's health change, their situations change, their desires change, circumstances change. There may be an issue of futility involved where it's no longer appropriate to have a full code, for example. But just be aware that people that you wouldn't know can change it on you when you are incapacitated, do have that authority. So you have to make sure that your healthcare provider and your agent, for example, in the healthcare power of attorney, understands what you would like to do under those types of circumstances. Then I'll spend some time on surrogates. As I mentioned, it's not the same terminology as surrogates that you use in the English language or that is used in many other states. Surrogates has a very specific meaning under Hawaii law. And as a preview, that will be the individual who is not an agent, who is not under a healthcare power of attorney, is not a guardian, and has the authority to make healthcare decisions. And we have a peculiar system in Hawaii for figuring out who is a surrogate for healthcare decisions when there is no guardian and no healthcare power of attorney that can be used. Now, for alternatives to guardianship and conservatorship, we now go to financial and legal matters. Once again, we see the powerful and power of attorney under the Uniform Power of Attorney Act. We also see living trusts, which are very useful tools. Um, as a separate discussion, we can talk about the benefits of a living trust for estate planning purposes. But living trusts can be a very effective tool for managing property and assets, other assets such as bank accounts, cars, uh, anything that you can hold title to during the lifetime of an individual when they become incapacitated. So living trusts are very useful tools for both uh, estate planning purposes, but also for planning for future incapacity. Then we have such practical things as joint accounts and property management, where we see you may be on an account with mom or dad, and you are helping them with that. All of these alternatives have pluses and minuses, and we see the joint account as having some very serious dangers involved that I'll go into a little more detail. But on that joint account, we recently received a case where the grandson was reported the by the child, and the grandson is the nephew of the child of this mother, and this grandchild of the older person, now with dementia, um, gave a lot of trust to this person, and everybody thinks that she was fooled into not have into making a joint account with rights of survivorship. So the one grandchild is going to receive most, if not all, of a very large estate of this person, because he was being helpful to grandma to pay her bills. And everybody looked to him and say, okay, we got this wheelchair or whatever, we need to pay for an upgrade to that, whatever they needed. And so I said, sure, 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 sure. Then it turns out that he owns everything upon her death. So they're looking into, before she dies, what do we do about that? For certain accounts, such as for Social Security and for veterans benefits, there are such things as representative payeeships for Social Security and appointed fiduciary for veterans benefits that can be used as an effective alternative to getting a conservatorship for those matters, if that's the item in question that people need to have access to for the support of the Social Security beneficiary or the veteran. Okay, so let's look at powers of attorney as an alternative to guardianship and conservatorship, certain parts of guardianship, again, not the healthcare. There are different types of powers of attorney, but before we get to that, I put in red capacity because we get calls from people saying, oh, the geriatrician says mom now finally has such a high level of dementia that she's no longer capable of making decisions or to taking care of her finances. So they encourage us to go talk to a lawyer. Well, and to get a power of attorney. It's too late under most circumstances. So capacity is a requirement in order to execute a power of attorney. So the attorney would assess the individual to see if they have sufficient capacity to execute a power of attorney and that they were not under undue influence. So there are different types of powers of attorney. Um, There are durable, all these terminologies, durable, springing, general, special, and then healthcare in parentheses, because we know that under the Uniform Power of Attorney Act, you don't put the healthcare powers in there. But very quickly, durable means that the power of attorney can continue through the incapacity of a person. Under the old law, the default was that unless you specifically address the issue, the power of attorney was not durable. But very quickly for this slide, the default under current Hawaii law since 2014 is that it is that will continue through the incapacity of the individual until the person's death. A springing power of attorney is a power of attorney that springs into effect upon a certain condition. So under the old law, very often people would say, if I should become incapacitated, then this power of attorney springs into effect. Under the new law, by default, the power of attorney is effective immediately and is durable. So you don't need to have it spring into effect upon incapacity. But if you don't want people to have control immediately and you're perfectly capacitated yourself, you're just planning for future incapacity, you should consider having that power spring into effect only upon your incapacity, because otherwise your agent can use that power of attorney for good or for bad sometimes. So those are considerations. There are general powers of attorney and special powers of attorney. General powers of attorney attempt to provide many powers to the individual, and those are general powers of attorney are those types of powers of attorney that you would look to as alternatives to guardianship and conservatorship. Special powers of attorney limit the powers, and sometimes you may wish to limit the powers if you don't quite trust an agent completely. So if you want the agent to have the authority to sell your car, you shouldn't necessarily give them a full general power of attorney, because they can use the power of attorney for other things. But that's a very individualized decision. Once again, healthcare, and we'll talk about healthcare when we talk about advanced directives, but healthcare is not included in the realm of under the Uniform Power of Attorney Act. But this slide is for general terminology. Other terms, the principal is the person giving the power to the agent. The agent is the person who receives the power. Under the old law and under old practice, very often you would see the term attorney in fact. That is now changed to agent. So in the past, you could see the term agent or attorney in fact, but now it's just agent that you will see. But if in one of the old documents you see attorney in fact, that's an agent. Of course, there are dangers involved in powers of attorney. Powers of attorney in some literature have been seen as licenses to steal, if you want to be that dramatic. So it's best to plan for the worst. So think of it as a potential license to steal, but put in place protections. I'm not saying don't execute a document, but be aware of the dangers that may be involved. So here's the new or 2014 Uniform Power of Attorney Act. It's in a new chapter in the in the um, in the statute. It provides for general or special or limited powers of attorney. Healthcare powers and some other powers are not included in the Uniform Power of Attorney Act. Um, I think I've reiterated that and stop nagging, but that for your post quiz, you'll know that nope, you can't have it in there. You shouldn't have it in there. Capacity is key once again. So I'll talk about capacity because this webinar is on dementia. You have to have sufficient capacity. If your loved one has diminished capacity, it doesn't mean that you can't take that person or have the person Zoom in with a lawyer these days until things get back to normal. But it's important that the attorney get a sense of the capacity of the individual. There are specific protections provided under the Uniform Power of Attorney Act. So when I say danger, danger, there are protections to the principal, the um, agent, and persons accepting power of attorney. The execution can, under the statute, be authenticated, and I'm suggesting that it should be authenticated. And the authentication under the statute merely means that it's notarized. Under this new or 2014 law, so it's getting kind of old, statute, you can make a power of attorney that doesn't need to be notarized, and people may accept it. So banks may accept it. But the difference is if it's authenticated, otherwise known as notarized, then under most circumstances, it generally must be accepted. Under the old statute, nobody had to accept a power of attorney, but under this statute, yes, it must be accepted, or uh, uh, the person receiving it, let's use the example of the bank, may ask for a certification from a lawyer saying that this is authentic and good power of attorney, or sometime it may need a translation if it's not in English, or it may need a legal counsel's opinion. But generally speaking, if it's authenticated, it must be accepted. So authenticated again means notarized. So that's where I say it can be, but it should be authenticated if you want it accepted. It's durable by default, or it can be springing. So remember that if you don't want it to um, be have any, so the two concepts are durable by default. And so if you don't want it durable, you can say that, no, my agent's powers expire upon my incapacity because you don't trust them anymore. You could have another plan with another agent where then it goes into effect springing. So there are a variety of tools of the trade that attorneys can use. The agent's certification is included in the statute, and that provides some protection for the principal because the agent actually will sign and have notarized a certification that that they understand the duties and that they have a fiduciary responsibility to the principal. But and they also will note in there that the court has jurisdiction should they breach this fiduciary responsibility. The court has jurisdiction at any rate over any agent, but sometimes it'll just put a little fear in the agent's minds that, well, maybe I shouldn't take advantage of this power of attorney. So they are to act as a fiduciary for the benefit of the principal. Again, the dangers can be used as a license to steal. We saw a case where a sister did that and transferred ownership of her sister's house to her own child. So now the nephew and the older person have their names on the house together, and now the individual is incapacitated. So it's a mess, and there are dangers. Here's where the dangers start and get worse if you're worried about it. This would create a general power of attorney if you look at the bottom of this list and you see all preceding subjects. So if you initial that, that means for real property, tangible personal property, stocks and bonds, commodities and options, banks and other financial institutions, operations of an entity or business, insurance and annuities, estates, trusts and other beneficial interests, claims and litigation, personal and family maintenance, benefits from governmental programs or civil or military service, retirement plans, and taxes. Well, that's quite a list, but the description of what's included in that list goes on for dozens and dozens of pages. So you should know what you're initialing, and especially if you're initialing all preceding subjects. It gives a lot of power. So basically, you're granting all powers that you have to another person. With the next slide, which we don't recommend that everybody or many people execute. These are the so-called hot powers under the law, and you see even more dangers here. It's the grant of specific authority, and under the statute even it says optional. My agent may not do any of the following specific acts for me unless I have initialed the specific authority. You can see that it grants a lot of power. Create, amend, revoke, or terminate an inter vivos trust. The trust that I mentioned before as an alternative, and we'll talk a little bit more about the trust as an alternative to conservatorship. Well, your agent can create, amend, revoke, and in the case of if you made one already, to amend, revoke, or terminate that trust, make a gift, create or change rights of survivorship in which you may have, and combined with the create or change a beneficiary designation. That's a lot of power for a bank account, survivorship issues of accounts, and who for pensions, for example. Authorize another person to exercise the authority granted under this power of attorney. So let's say you have two children and one you wouldn't trust as far as you could throw them. So you give the authority to the other child. But if you mark this box, that child can authorize the other child that you don't trust to exercise the authority. Of course, under the law, there are protections, and the court has jurisdiction. And if they act in a non-fiduciary manner, the court can rectify that situation, but the money may be gone, or nobody may know about this because powers of attorney are generally not seen by anybody except within the confines of the agent and the principal agent relationship, and maybe within the family, but maybe nobody will know what's going on. With these powers, hot powers can waive the principal's right to be a beneficiary of a joint and survivor annuity, including survivor benefit under a retirement plan, and exercise fiduciary powers that the principal has the authority to delegate. So you can delegate those powers that the principal has the authority to delegate, or exercise the powers that the principal has the authority to delegate. So very powerful document, very dangerous. That's why you need to talk with your lawyer before executing these types of documents. And you can see that why it's important that lawyers attempt to make sure that the person has not only capacity, but is not under any undue influence. And then is there a plan later on to follow up to see what's going on? In the elder law practice, this can happen because you can say, look, attorney, I want you to continue to be my attorney for years and years and years, and once in a while check in on me and to make sure that everything's fine and to have a continuing relationship. Many attorneys will just say, no, we're done with that. I did the power of attorney. You're no longer my client. And if you want to connect again, we have to enter into another agreement. So life can be complicated, even if you want that attorney to stay in your life. Very briefly, I already mentioned some of these, that the general differences to the law prior to March of 2014. There's a default now of durable with respect to a power of attorney not terminated by the principal's incapacity. The default is now the power of attorney is effective immediately unless specifically provided otherwise. An interesting thing, it revokes a spouse agent's authority upon divorce unless expressly provided otherwise in the power of attorney. So if you get divorced and you no longer want your ex-spouse to have the authority and the power of attorney, the law is good. But very often these days you see ex-spouses continuing to help each other. And so this is where it's very individualized. And then I mentioned already the agent's certification to the validity of the power of attorney and the agent's authority. Trusts, it's a whole several sessions about there are different types of trust. The testamentary trust in parentheses is not the type of trust that you use to plan for future incapacity, because a testamentary trust is a trust that's included in a will. So if you hearken back to older days, you may have had a will that says, I give everything to my spouse, but if I should die, it goes to my two children. But your two children are 2 and 4 years old. So in that will, you say, I give it in trust to Auntie as trustee for the benefit of my children until they reach such and such an age. So that's a testamentary trust, will not work for your own planning for future because the testamentary trust only goes into effect when you die. We're talking about a living trust, which can be revocable or irrevocable. So it's the living trust that you establish. The important factors for a living trust is that it be funded. You can have the greatest trust ever crafted, complex as much as you want with all the terminology. Even the best trust attorney will have a hard time figuring out. But if you don't put anything in it, it's worthless. So it can be in that rich Corinthian binder. But if you, let's say you are desirous of having the trust manage your bank account and to have control over your home, for example, to manage your home and other property, you have to legally transfer it into the trust. For a home, it would be through a deed, and for bank accounts and automobiles, it would be through changing how it's held by going to the bank and signing documents, or to the DMV if ever you can get to the DMV again. That's another COVID issue, of course. Um, there are revocable trusts, which you can revoke at any time. You change your mind, you change things in the trust. This is the normal way. There are certain irrevocable trusts that can be, some people don't know that they signed an irrevocable trust, and years later they call and say, how do I revoke this irrevocable trust? Well, with great difficulty, if at all. There may be certain good reasons to have an irrevocable trust, but generally speaking, it should be revocable, that you can revoke it at any time. I did mention, the thought came into my mind, I did mention that you can transfer your home into your trust. But if you're thinking about Medicaid planning and eventually needing Medicaid for long-term care, if you have your home in a trust, it's no longer an exempt asset. It's just an aside, but it gives you a hint as to the second to last slide that I'm going to show you, that many, many things need to be taken into consideration. This is where the attorney will say, oh, hold it. There may be some Medicaid issues if you transfer that home into your trust and you're going to plan for Medicaid. So that's why an attorney should be consulted. There are also special needs trusts that can be set up for individuals who have special needs, certain disabilities, either younger or older individuals, and then they would still be able to qualify for certain public benefits, but that's a whole specialty area in and of itself. I put danger on this slide too, because just because a person is a trustee, that name implies trust, doesn't mean that they can't take advantage of the situation. So be very careful about this, about setting it up, about whether it's irrevocable, about what you put in the trust or you fail to put into a trust, because just setting up a trust doesn't necessarily mean that you have an effective alternative to conservatorship. Money management, there are personal money managers or organizations that handle finances for an individual. They can help with paying bills, managing finances, handling investments, troubleshooting. And of course, that takes a lot of burden off of individuals. Very often they will ask for a power of attorney in order that they have access to your accounts. So there are some dangers involved, but generally speaking, if it's a reputable organization or individual that you know of that that is bonded and insured and licensed, then this is an effective way, can be an effective way of handling some of the alternatives to conservatorship for an individual who has a hard time coping with their finances. These days, online banking and including automatic bill paying is very is an effective tool to avoiding a lot of the issues we see with conservatorship. Of course, you're going to see a lot of danger, starting with the bottom bullet of the common use of ATM access, where grandma tells the grandchild to go to the ATM, we need some more money. And we see that, unfortunately, where that grandma is taken advantage of. The individuals with access to online account, of course, can control everything that goes on, including taking out all the money. But for most families, this is great for managing the assets, paying the bills. They're not going to take out all the money for themselves. This is family. So it's a good alternative to having to have a process that may lead to conservatorship. You have effective use of powers of attorney, of trusts, of and online banking, automatic bill paying. It makes it a lot easier for everybody. Of course, periodic monitoring is helpful for siblings that don't trust each other. The monitoring may include mom or dad saying, okay, every year you get together, show everybody the accounts, see where the money's going. So that generally speaking may be useful, including the use of power of attorney and being a trustee. So it's up to the individual setting up the alternative when you're dealing with family issues and family hurt and people feeling that somebody may be taking advantage of you.